If you think that a food and or beverage manufacturer or retailer can stay on top of all the important regulatory happenings and threats by simply monitoring the Federal Register, you would be mistaken. In addition to the policies that come out of the roughly 20 different federal agencies that have some influence over food regulation, there are lawsuits, petitions, campaigns orchestrated by consumer groups. There are a lot of challenges. Hello, I'm Jason Huffman, Editor-in-Chief of Food Chemical News. Welcome to the Knife and Fork Show. Remember those commercials for 7-Up back in the early 70s? They called it the Un-Cola. Well, I kept thinking about those commercials while struggling to come up with a name for this episode and a category that would cover all these things that are coming at food companies that could affect their food safety practices, labeling, formulas, and even packaging. They aren't really regulations, but they can be just as difficult. I called them the Unregulations. Joining me today to talk about some of these developments is attorney Sarah Brew, a partner at Fager Baker Daniels in their Minneapolis office. Sarah has been practicing law since 1991 and has defended or counseled food companies in some of the biggest cases. She just gave a big presentation for food companies on minimizing the risk of litigation. And she's in the DC area, at least partly because of a conference we're going to do tomorrow on FSMA, the Food Safety Modernization Act. Sarah, there are so many things going on in or around food safety and food regulation today that aren't necessarily coming through the Federal Register. Where did this all begin? Where does this start?
I think, Jason, that there's been a real increase in food activism. Consumers are much more interested in what they eat. In the old days, long ago, the types of things that we would see would be lawsuits by individuals who maybe bit into a chicken pot pie and found a chicken bone, and they would get upset enough that they would call a lawyer.
Oh, I remember those stories.
Yeah, but now we have people, when they are in the grocery store, before they even take the chicken pot pie home, they're scrutinizing what is on the label, what is in here. How is this product made? Is it made in a sustainable way? Is it made in a way that humanely treats animals? Food has so much more connotations and means so much more to people today, and they've become active around that. As you pointed out, there are petitions, there are websites and industry groups, and beyond just litigation, people really want to have an influence on food policy.
When I was introduced to these issues a couple of years ago, getting into this stuff, it was mostly about the food safety litigation. It was the foodborne illnesses that people were suing food companies over, and trying to change their practices. And that's still an issue today. That hasn't gone away. I think I told you I was going to call Bill Marler, who's one of the biggest attorneys in this area, in terms of representing plaintiffs against companies on foodborne illness-related litigation. And I asked him, I said, and I've seen Bill put figures forth before this month, so I knew he was comfortable about it. I said, how much have you generated in terms of settlements, judgments, that sort of thing? And he told me since '93 about $600 million. That's just his firm. Yeah. And he's not the only firm doing this. So, I mean, that's still out there.
Yeah, Bill's not the only one, but Bill is probably the most successful and probably has the biggest number. And he really started, his practice in foodborne illness started with the Jack in the Box outbreak. Yeah. And that really started this focus and the idea that people didn't necessarily just get sick here or there, that there could be these big outbreaks, and advances in public health detection and scientific testing really helped identify some of those big outbreaks. And we saw, especially in the last decade or so, quite a few big outbreaks that led to a lot of litigation. And I still think consumers expect, of course, safe food. That's sort of table stakes. But now consumers, beyond just expecting safe food and having no hesitancy to sue when their food is not safe, they're looking for more from their food. They want food that's organic or natural, and they've focused less on, is this food safe, because they assume it is, and rightfully so, and more about, how is the food labeled, how is it made, what does the food mean, is it healthy? All of these much more amorphous, intangible things that really sell food today.
Now, you've represented probably some companies or counseled some companies in this area. Are they claiming fraud when they come at the food companies in these lawsuits?
Yeah, a lot of these lawsuits that you see now, Jason, are consumer fraud class action lawsuits. So what the plaintiffs' lawyers are saying is there's something about the labeling of your product that is deceptive. And that deception is misleading people and causing them to buy this product, and they're not really getting what they're bargaining for. So a lot of times they will focus on a term like the word natural, and they'll make the claim your product really isn't natural because it has artificial colors, or it has high fructose corn syrup, or it's made with genetically modified organisms. And using that term is deceptive, and we're going to sue. But other times they focus on things that are very much standard regulatory errors that in the past FDA may have given you a warning label. For instance, if your product didn't meet with a standard of identity, such as cheese, yet you were calling your product cheese, in the past you'd worry about FDA giving you a warning letter and you would address that and you would sort of go on. Now you don't just have to worry about FDA out here in this regulatory world, you have to worry about this unregulatory world with these lawyers suing you because you're calling your product cheese when they say it doesn't meet the standard of identity for cheese.
You just covered two topics I want to zoom in on a little bit. And I'll start with the one that you were just talking about. In a presentation you did recently, you gave a bar graph to show the number of FDA warning letters, NAD reports, private litigation, and CSPI warning letters since 1997. And you show the numbers spiking over the past 2 years. And I guess we should probably qualify what NAD stands for, and also CSPI, which is a consumer group, Center for Science and the Public Interest. But what are NAD reports?
NAD is the National Advertising Division of the Better Business Bureau, and those are competitor claims. So that's where a competitor is coming in and saying, you're doing something deceptive with your labeling or your advertising to gain a competitive advantage. It's sort of the company side of the same consumer fraud
type of complaint. It's not just consumers coming at food companies, it's food companies that are competing against them.
Exactly. Yeah. So when we counsel food companies, when we talk about what's on your label, you have to think about everyone who's going to be looking at that label. And it's not just FDA or FTC, it is your competitors, and it's consumers, and it's these, CSPI, it's these consumer groups out there as well.
The spike, though, over the last 2 years is remarkable in the number of cases.
It's been phenomenal.
Mm-hmm. Okay, so on the other issue that you touched on, we talked about natural claims, and you show a chart. I'm going to try to throw it over top of us while we're talking here.
Sure.
Hopefully that'll work. You broke down the percentage of cases that were ongoing and natural claims. About 67% of all the cases were ongoing. And then the number of percentage that were dismissed, 17.65. And then the number or the percentage that was settled, 19.61%. I notice there was no part of the pie for judgments against food companies.
No, there have been no trials. So typically how these suits go, the defendant will make some type of initial motion to dismiss. We know that preemption as a defense does not work in these natural cases because FDA has done nothing that has enough of a regulatory effect to preempt any claim that a product can't be labeled natural. It's a little different in the USDA world, but on the FDA side, that preemption defense does not work for companies. So they'll try to find out some other reason to dismiss. If that doesn't work and it sort of gets to the class certification stage, that's when they usually settle. So we have many that are, as the chart shows, that are ongoing right now. We have a few that have been dismissed for technical reasons. Some of those have been refiled, so that's a little, that sliver of the chart or the pie is a little misleading. And we have a lot ongoing right now, and some that have settled. And unfortunately, the ones that have settled for some very big numbers in the millions of dollars. And that just incentivizes others to bring similar suits. And this is an area where we see a lot of copycat suits. We see one plaintiff's lawyer sue a company about a certain product, and others will jump on that same product or different products in the same line, or they'll allege classes in different states. So it's created just a really massive wave of litigation.
The one area that we didn't spend a lot of time on, I just want to cover it briefly before we close up, and that is on the consumer petitions. They're not going to court just yet, but there's a website called change.org, for example, that's been gathering a lot of these petitions. And we've actually seen where food companies have changed their formulas in response to these petitions. There was an incident recently with a popular manufacturer of coffee that had a drink that involved crushed beetles. Well, now they're not doing that anymore because of a petition that was started on change.org. You must be seeing a fairly sizable number of those types of cases.
Yeah, and it all, that ties in, Jason, very much with the social media right now. I mean, there's so much interaction between food consumers and the companies at the social media stage, people want to know what's in there, and they will not hesitate to express concern if there's something in there. And that, of course, companies listen to their consumers and they want to respond to their consumers, and they will change ingredients. And it's interesting you mentioned the Uncola and 7-Up, because 7-Up is one that just recently got a warning letter from CSPI, the Center for Science and the Public Interest, that said, we don't like that 7-Up is labeled that it has certain antioxidants. And the response by 7-Up was to take that off their labeling. So they listened.
Well, they said, we wrote about that. And the response, it was the Dr. Pepper Snapple company. And they said that, they were planning to do that anyhow.
Right, yeah. And that could be, we're in a different climate now with food companies. They scrutinize what's on the labels so much. And I think in the coming few months, you will see a lot of changes in product labels, because before, what would just automatically pass through marketing without much legal review is now...
Is marketing starting to pay more attention to the regulatory folks at the company?
I think so. I think what I'm seeing in-house is a better cooperation between marketing and the lawyers, because people are beginning to understand how significant the risk is.
Okay. This is such a monstrous topic that I hate to end it after 10 minutes and let Sarah Brew go, but hopefully she'll come back to Washington again and join us in another episode of the Knife and Fork Show. Thanks for watching.